People versus Grant. Appellate Court of Illinois' 4th District. Reardon Justice. The defendant, Seth Grant, was sentenced to 3 to 9 years in the penitentiary after a Logan County jury found him guilty of aggravated battery and obstructing a police officer. The court entered judgment on both verdicts but only sentenced the defendant for the offense of aggravated battery. On December 13, 1974, the defendant was a patron at a tavern known as the Watering Place in the city of Lincoln, where he consumed 4 drinks consisting of whiskey and cola during a 2.5-hour period. The defendant then witnessed an altercation between another patron and the tavern owner. The Lincoln police were called to the scene and they forcibly escorted the other patron outside where he continued to resist arrest. A hostile crowd of approximately 40 persons accompanied the police and patron as they exited from the tavern and approached the officer's automobile. The crowd was cheering for the patron. Suddenly, the defendant burst through the crowd and using a parking meter for leverage, he leaped into the air, striking Officer Raymond Vonderah twice in the face. Thereafter, Officer Michael Yarcho placed the defendant under arrest and forcibly led him to the officer's automobile. Yarcho testified that the defendant was very upset and that great force was required to place the defendant in the automobile. Another officer, David Morrow, testified that the defendant was excited, agitated, and upset. Morrow also stated that the defendant had not been involved in the altercation prior to his attack on Vonderah. The defendant was transported to the Logan County Jail and placed in a cell. Approximately 1 hour after being arrested, one of the jailers discovered the defendant lying on his cot, grasping for breath. Defendant's eyes were fixed and his back formed a rigid, reversed arched, typical symptoms of a grand mal convulsive seizure. The defendant was immediately transported to a Lincoln hospital by the Lincoln Fire Department and then to a Springfield hospital where the defendant remained until December 23, 1974. The record on appeal reflects that the defendant has a complicated legal and medical history. The defendant suffers from an illness known as psychomotor epilepsy. This history includes a number of violent attacks on other persons which have varied in severity. In some, physical assistance from others was required to subdue the defendant. One, a knife assault in a hospital, was of such violence that a police officer seeking to restrain the defendant was forced to use a weapon. The affray ended only when the defendant was shot in the pelvis and kidney. His past history is replete with emotional outbursts, and he has been convicted on separate occasions of involuntary manslaughter and aggravated assault. Defendant relies on his testimony that his mind went blank at the watering place and that he remembered nothing until he woke 3 days later. He stated that he had previous blackouts and that he takes medicine for epilepsy. Defendant also relies on Dr. Albert Luden's testimony that defendant has temporal lobe epilepsy with symptoms described as psychomotor and grand mal seizures. Dr. Luden expressed his opinion that at the time the offenses were committed, defendant was suffering from a psychomotor seizure which prevented his conscious mind from controlling his actions. The jury is not required to accept the conclusions of a psychiatrist, and the weight of the psychiatrist's opinion is to be measured by the reasons given for the conclusion and the factual details supporting it. Here, Dr. Luden stated that his opinion would be different if the defendant was not telling the truth. Analysis of the record on appeal discloses facts on which the jury could base their opinion that the defendant was being untruthful. First, defendant alleges that he cannot remember anything that occurred during the 3-day period following his arrest. The doctor, however, testified that on December 14, 1974, defendant was alert, awake, and in contact with reality. Officer Yarcho also stated that the defendant was alert and not confused when he was arrested. The defendant also responded in an appropriate manner when questioned about his personal history. Next is Officer Yarcho's troubling testimony that defendant's arrest required a great deal of force. Such testimony coincides with Dr. Ludin's statement that a person having a psychomotor seizure exhibits a great deal of strength. This testimony, however, as the state points out, must be contrasted with Officer Yarcho's later testimony that it took 4 men to place the defendant in an ambulance at the jail, while he initially took the defendant into custody by himself. Furthermore, Officer Yarcho testified that defendant was much stronger during the jail incident than he was during the arrest. Finally, Officer Yarcho stated that in his opinion, the defendant was in possession of his complete faculties and normal at the time of his arrest. The evidence showing that the defendant had a grand mal seizure at the jail does not necessarily reflect that the defendant also had a psychomotor seizure a short time before. While Dr. Ludin did say that sometimes a grand mal seizure is preceded by a psychomotor seizure, he did not say that this always occurs. The trial court instructed the jury on the question of the defendant's sanity by giving the following instruction, which is taken from the Illinois Pattern Jury Instructions, Criminal Number 24.1, 1968. A person is insane and not criminally responsible for his conduct if at the time of the conduct, as a result of mental disease or mental defect, he lacks substantial capacity either to appreciate the criminality of his conduct or to conform his conduct to the requirements of law. This instruction, however, fails to distinguish behavior by a person lacking substantial capacity either to appreciate the criminality of his conduct or to conform his conduct to the requirements of law from automatic behavior by an individual who possesses the requisite capacity. The term automatism is defined as the state of a person who, through capable of action, is not conscious of what he is doing. Automatism is not insanity. It is manifested by the performance of involuntary acts that can be of a simple or complex nature. Clinically, automatism has been identified in a wide variety of physical conditions, including epilepsy, organic brain disease, concussional states following head injuries, drug abuse, hypoglycemia, and less commonly in some types of schizophrenia and acute emotional disturbance. Psychomotor epileptics not only engage in automatic or fog-like activity, but they may also suffer convulsive seizures. Section 4-1 of our criminal code provides a material element of every offense is a voluntary act, which includes an omission to perform a duty which the law imposes on the offender and which he is physically capable of performing. While the Illinois Pattern Jury Instructions contain an instruction relating to this statute, that instruction was not read to the jury in this case. We hold that the interest of justice requires reversal of the defendant's conviction because the jury instructions are substantially defective in that they do not contain an instruction on the defense of involuntary conduct. We note that courts in other jurisdictions have held that the defendant who introduces evidence of abnormal mental condition bearing upon the state of mind required for the crime with which he is charged is entitled to an instruction drawing the jury's attention to that evidence. The entire record on appeal here, especially the testimony of Dr. Ludin, reflects that the defendant suffers from psychomotor epilepsy, which is not insanity. The record reflects that the defendant may have been acting in a state of automatism when he attacked Officer Vonderai on December 13, 1974. We therefore leave the factual resolution of this question to a jury that is properly instructed. Although a voluntary act is an absolute requirement for criminal liability under Section 4-1 of our Code, there is no requirement that every act preceding the actual commission of the offense is voluntary. Thus, the jury may on remand determine that the defendant attacked Officer Vonderai while in a state of automatism, but that he nevertheless committed an offense for which he is criminally responsible if he had prior notice of his susceptibility to engage in violent, involuntary conduct brought on by drinking alcohol beverages or by some other conscious, casual behavior. The Illinois Code provides for the affirmative defense of insanity and requires that every offense be the result of a voluntary act. Our legislator has provided that a person found not guilty of an offense by reason of insanity can be committed to a mental health facility for treatment, although no such provision applies to an alleged offender who commits an involuntary act. On remand, the defendant will again run the risk of being convicted for that offense of aggravated battery or obstructing a police officer if the jury finds that he was not insane when he attacked Officer Vonderai and that he either consciously committed the offense or recklessly brought about his alleged psychomotor epileptic seizure and its accompanying state of automatism. As some commentators have suggested, the jury plays an important role when the defense is raised. Automatism as a result of psychomotor seizures should be a valid criminal defense. The dearth of cases employing this defense suggests that the problem is one of proof. If one is sane immediately prior to and after the unlawful act is committed, it is difficult to establish that a particular violent act occurred as a result of psychomotor seizure. If the jury finds that the defendant was sane but not responsible for the attack on Officer Vonderai, then he cannot be committed for the offenses. We find this course to be mandated by our legislator, which only provided for the commitment of persons who are criminally insane. In view of the fact that we are remanding this case for a new trial, we do not address the question of whether the 3 to 9 year sentence of imprisonment imposed by the trial court is excessive, reversed and remanded with directions.